Hello, everyone, and welcome to Uncivil Law. I hope you are doing well today. And we are here with yet another edition of Live Supreme Court React, but this time actually live. Actually live. We have improved since yesterday. And it's a more interesting case than yesterday. Not that yesterday's case wasn't interesting, it's just, maybe not the most consequential case of all time. Or maybe it is, depending on your point of view, but a little bit more technical. But today's case is less technical in nature. Today's case is more interesting and going to some fundamental values. So the Supreme Court is going to start its oral argument in about 10 minutes, so that gives everyone a chance to show up and join the stream. And I'm going to read you a little bit about the facts of this case. This is United States Agency for International Development versus the Alliance for Open Society International. You gotta love these names. All right, here are the facts of the case. The Alliance for the Open Society International and other organizations receiving funding from the U.S. government to help with their mission of fighting HIV/AIDS abroad. All right, so we got a non-governmental agency, NGO, receives money from the U.S. government to help fight AIDS. Okay, great. The government provides these funds on the condition that no funds be used to provide assistance to any group or organization that does not have a policy explicitly opposing prostitution and sex trafficking. All right, so we're going to give you money to help fight HIV/AIDS, but it comes with a condition. We're not going to give you money if you do not have a policy that prohibits, if you do not have a policy that explicitly opposes prostitution and sex trafficking. So not that you can even be neutral about it, you have to expressly oppose it. So that's a viewpoint requirement. But it's coming through the spending clause, right? So that's the tension, right? Normally, if we talk about the government imposing on a viewpoint limitation, we're looking at strict scrutiny or per se unconstitutional, but this is spending, right? It's government spending its own money. So does that come with different kind of rules under the First Amendment? That's the kind of question we're looking to. All right. So now the background. In a prior case, which has the same name, so in the prior case of United States Agency for International Development versus Alliance for Open Society International, same parties, decided in 2013. So this is not the first time these groups have been at it. These same groups had a case decided in 2013, okay? In that case, the court held the condition compelled speech in violation of the First Amendment, all right? So the Supreme Court said, no, you can't do this because it's compelling speech. It's requiring people to speak, and that's another level of like constitutional restriction, right? So not only is a viewpoint-based restriction, we're requiring you to say something. So that's also a whole other category of problem under the First Amendment. That was a ruling in 2013. The government continued to apply this condition to foreign affiliates of the Alliance for Open Society International, and the organization sued, asking for permanent injunctive relief. All right, so keep track here. Initially, the initial complaint was, we are a U.S.-based organization, the Alliance for Open Society International, and you're compelling our speech. Can't do that. All right. Then the government turned around and said, okay, what we're going to do, though, is we're going to continue to apply this to foreign affiliates. So not your U.S. organization, but foreign affiliates. So again, we're changing the First Amendment analysis because, as you might expect, the First Amendment typically, although not always, applies to U.S.-based speech. It applies to U.S. citizens, U.S. protected people. The First Amendment does not apply everywhere. But then again, it's the government acting. So maybe it does. That's the issue, right? The district court granted relief, and the United States Court of Appeals for the Second Circuit affirmed. Thus, the question: does the court's prior decision in the prior case, U.S. Agency for International Development versus Alliance for Open Society International, which holds the First Amendment prohibits Congress from enforcing a law that would have required U.S.-based organizations that receive federal funds to fight HIV/AIDS abroad to have a policy explicitly opposing prostitution and sex trafficking, imply that Congress may not enforce that law with respect to entities not directly involved in the case? Okay, great. That is the issue. So we got some First Amendment law, we got some spending clause, so we got some First Amendment law issues, we got some spending clause issues, and we also got the interoperability of the First Amendment as it applies to overseas when it's U.S. government-based action. Interesting questions abound. Interesting questions abound. Yeah, so that is the issue. $2 from Phoenix saying, is prohibiting speech a lower bar than forcing it? Yes, much less, much so, yeah. There's a case from like 1920s or 19 teens in the U.S. Supreme Court dealing with compelled speech explicitly, and the answer was no. Just basically no. You can't do that like basically ever. You cannot compel someone's speech. You can't force the government to say, you can't force someone to say something. So yes, there's a much different standard in U.S. law, much different standard, where you prohibit someone from saying something versus forcing them to say something. So yes, that is a huge difference in U.S. law, big difference. Because your freedom of speech, forcing you to say something from your mouth is thought to be a bigger infringement than prohibiting you from saying something. That's probably right. It seems right to my head. So yeah. So we're going to do this oral argument at 10 o'clock. So we got 5 more minutes, guys, because we are doing it live. We are doing it live. So we are waiting for the Supreme Court to start because, we're doing it live. So, that's where we are. So, talks amongst yourselves for a few minutes, I guess. I'd have to actually go back and read that 2012 case or 2013 case or whatever it was they referred to see what the rationale for that is, because the idea, if it's the government's money, the government may be able to. It's different if the government is giving you money, right? Because it's their money. So the idea that they would be able to condition that based on their own subjective preferences is one thing. But then again, you talk about the First Amendment and Congress discriminating against different viewpoints. So in the interoperability of the spending clause versus the First Amendment is a really interesting philosophical jurisdiction. It's like, well, Congress can't make any law, but Congress is spending money. So that's not really making law, it's spending money. But then again, it's discriminating in a way, and they can through money create speech they want to create and disfavor speech they want to create. And the government has so much money that becomes a First Amendment problem because, again, it's government money. So the idea that the government can discriminate through the expenditure of money is an interesting philosophical tension that I'd have to go back and read the earlier case to really think through the issues there, because it's not immediately obvious. It's not immediately obvious that to me that the Congress shouldn't be allowed to spend money any way it wants, and because the government can have a viewpoint itself. That's pretty well established. That's why I'm like musing about this, right? So it's pretty well established the government can have a viewpoint. If it was spending its own money through its own agency, for example, if it was the NIH, and it said to the NIH, we want you to have this money and we want you to further these objectives, that's constitutional. So even if like that's a particular viewpoint, that's allowed because the government itself is allowed to have a viewpoint. So if it was doing it through the apparatuses of a government agency, we wouldn't be having this problem, right? So the idea that the government can use money to forward a particular viewpoint is well established as long as it's an agency. So why isn't that true if it's a third party? It's not immediately obvious to me. So, I'd have to go back and read the earlier case to see on the rationales on that, what the court was thinking, to see whether or not I agree or not. But at the moment we're trying to figure out is, taken as a given that it applies to a U.S.-based non-governmental organization, does that apply to foreign-based NGOs? I assume affiliated with the U.S. group or not. I don't know that it would turn in my own head on the fact that the foreign NGO, is formally affiliated with a U.S. NGO or even a subsidiary of the U.S. NGO. I don't know that it turns on that for me, but maybe it does the Supreme Court. This is why the Supreme Court gets all the fun questions. This is why the Supreme Court gets all the fun questions, because we're going to the deepest implications of some of these principles. Like, does it matter that this NGO is affiliated with the U.S. organization? Is that what it turns on? Does it matter how affiliated? Does it matter if it's a subsidiary or like only like a loose affiliation? What if it's no affiliation at all? These are what does this mean for Congress's spending power? And does the First Amendment apply overseas? Does it apply overseas to an NGO that is affiliated with us? And so the complications of the interaction of these principles gets really, really tricky. This is what the Supreme Court gets paid for, guys. Fun times. Yeah, this is complicated stuff. This is super complicated. And that's why I love Supreme Court stuff so much, because it is at the root. It's at the root of philosophy. It's law to me. What makes law so much fun for me is its practical philosophy, right? The law, at least to me, embeds philosophical principles, and it's embedded in formal words, so it has operative legal effect, but it's applied philosophy. And so, like, you look to these philosophical principles, and then you're like, well, how do we apply that? And that's where, like, those abstract meets the real. Pretty exciting stuff for me. So, okay, so I have 10 o'clock. So, is the Supreme Court going to start? Oh, here we go, guys. Go. 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 Okay. We're live. Exciting. Here we go. We are very, very live.
Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
This morning we will hear argument in Case 19-177, the United States Agency for International Development versus the Alliance for Open Society International. I note at the outset that Justice Kagan is recused in this case. Mr. Michel?
Is that Chuck Michel?
Mr. Chief Justice, and may it please
it's
the
Christopher
Court.
Michel. Different
20
guy.
years ago, the HIV/AIDS pandemic was devastating the world. In response, President Bush proposed and Congress adopted the Leadership Act. Since reauthorized 3 times, the act has committed nearly $80 billion to global AIDS relief. And it has worked, saving more than 17 million lives in the most successful American foreign aid effort since the Marshall Plan. The funding condition at issue here requires recipients to have a policy opposing prostitution and sex trafficking, which Congress found are coercive practices that spread HIV/AIDS and degrade women and girls. This court held that applying that condition to respondents, domestic entities, violates the unconstitutional conditions doctrine. But respondents sought more, and the question now is whether the condition can still be applied to foreign grant recipients operating abroad. It can, for 2 straightforward reasons. Foreign entities lack constitutional rights, so they cannot bring an unconstitutional conditions claim. And neither can respondents, because they are not subject to the funding condition. Thanks to their victory in this court, respondents can accept and use funds without any compelled speech. To be sure, respondents can choose to affiliate with foreign entities that must comply with the policy condition. But any effect on respondents' message is now a product of their own choice, not government compulsion. Respondents' contrary view is startling. They would allow U.S. nonprofits to export constitutional rights to legally separate foreign entities abroad simply because they share similar brands. That novel theory has no basis in this court's prior decision. It could undermine long-standing regulations of foreign speech, and it has no practical justification. For 17 years, foreign recipients have adhered to the policy condition without harming the AIDS relief program or respondents' speech. This court afforded respondents all the relief they deserve. The decision below should be reversed.
Counsel, one thing that I think is not clear from the record is the precise relationship between the domestic entity and its foreign affiliates. We know that there are no formal corporate ties, but that these entities share the same name, the same logo, the same brand. What would you require beyond that before attributing the speech of the foreign entity to the domestic one?
Mr. Chief Justice, you're correct that the record is not particularly thorough on that issue. Despite 15 years of litigation on this matter, the district court ultimately entered the injunction at issue here based simply on letter briefing. But our position is that the formal distinction between the two entities, the U.S. entity and the foreign entity, is all that is required to attach separate legal rights. Of course, it's important to note that respondents and the foreign entities that they claim as affiliates made the choice to be separate legal entities. That choice, of course, has certain benefits for them, such as shielding them from liability, but it also has certain burdens.
Is it reasonable to insist on formal corporate ties in this context? I gather that it's undisputed that to be effective in many of the foreign countries involved here, you have to operate through a foreign entity. That the effort would not be as effective if the American entity were the one actually on the ground in the foreign country.
Well, 2 points on that, Mr. Chief Justice. First, I think that is not true as a uniform matter. Many of the respondents, the U.S. entities, do in fact operate in foreign countries through branch offices. And as a result of this court's prior decision, they always have a choice to operate in that way without compromising their speech in any way. They are, in other words, completely in charge of their own message while also accepting Leadership Act funds. And to take your second point, if they make the choice to operate through a foreign entity because they decide that that is more convenient or more effective, they have to accept the bitter with the sweet, to be sure, operating through a distinct legal entity, but they're not without recourse. They can, for example, explain that the policy statement being issued by the foreign entity doesn't reflect their own views. Their free speech allows them to do that. And I would note, as
presumably it does reflect their own views. They have the same name, the same logo, the same brand. And I wonder if it makes more sense to think of the foreign entity as simply another channel for the domestic entity's speech.
Well, Mr. Chief Justice, with respect, I don't think it does. And I think, when that was the only option available, as it was in the court's decision last time, I can understand, of course, why the court decided the case the way it did. But now that respondents have a separate choice, in fact, the very choice that they were fighting for last time, any consequences of the choice to operate as separate entities is a result of their own decisions. And I wanted to note.
Yeah, that does make sense to me, that the idea that you have a separate entity that is legally distinct, and therefore, you can't
your guidelines,
can't do that.
Your affiliate guidelines actually support their argument. What do you think of that?
Justice Thomas, I don't think that they do as an initial matter, and even if they did, I think that would at most be a basis for challenging the guidelines, not the constitutionality of the statute. And to start with the first point, the guidelines, which are reproduced at pages 1A through 3A of our reply brief, simply provide that an entity can affiliate with a separate entity that has a different policy on prostitution and sex trafficking if it meets certain requirements. And there are 5 non-exhaustive requirements spelled out there. 4 of those would generally be satisfied by an entity that has legal separation. So I think it would be a rare circumstance that these regulations would ever result in the denial of funding to a foreign affiliate. And to make one related point, respondents themselves are no longer subject
That's a good
to
question,
the
Black
policy
Horse Cavalry,
requirement as a
about
result
the
of their
difference
prior
in the
decision
photographs.
this
I don't know
case.
the answer to that
So
question.
if they run afoul
But it's good
of
that you
these
pointed out. I
regulations,
don't
which
know the
simply
answer to that
interpret what it
question.
means to have a policy opposing prostitution
How this
and
guy
sex
get a
trafficking,
photograph and the woman
these
at DOJ didn't
regulations
get a
can't
photograph. I
be
don't know
a
the answer to
mechanism
that.
for depriving the respondents themselves of funds.
When this case was here last, I seem to remember it was about the domestic organization. What has changed since it was here? There was very little talk. The only time that affiliates actually came up was as an alternative to the enforcement procedures that were being used toward the domestic
Yeah, I mean, it definitely is as
organizations
simple
then.
as C-SPAN didn't have
So
one
what has
available, but why they
changed
didn't have
since
one
this
available, I
case
couldn't
was here
say. But
last?
yeah, I mean, because C-SPAN is the one that's putting together
Justice
these
Thomas,
photographs
you're
and the
exactly
overlay.
right. That was all that was
So,
at issue last time, and the only thing
C-SPAN
that has
didn't have it for
changed
some
is that
reason, but why, I
respondents
don't
have
know.
asked for broader relief. And although we fully accept the court's prior decision, we submit that respondents are simply not entitled to any further relief. As you suggest, there's nothing in this court's decision that contemplates or suggests applying the prohibition on applying the policy requirement to foreign entities overseas. So I think the court ought to simply analyze the claim under first principles. And as I said at the outset, I think 2 simple principles resolve the case. Respondents themselves are not subject to a funding condition, so they can't have an unconstitutional conditions claim. And the foreign entities that are subject to the funding condition have no constitutional rights, so they can't have an unconstitutional condition claim either. We do think that what respondents are asking for is unjustifiably bootstrapping this court's prior decision into global relief, and we simply don't think there's any basis for that.
Thank you.
Justice Ginsburg?
Mr. Michel, I have 2 questions. And the first is that the statute exempts certain non-domestic entities from the requirement to adopt an anti-prostitution policy, and those are the Global Fund to Fight AIDS, tuberculosis and malaria, the World Health Organization, International AIDS Vaccine Initiative, and any UN agency. What is the reason for the exemption? Why are these organizations exempt and not the organizations at issue here?
Justice Ginsburg, I think there are a few reasons for that. Those are, in the main, international organizations that are composed of their own separate sovereigns. And so I think it makes sense that Congress would have wanted to respect the sovereignty of the members of those organizations in a way that doesn't, of course, apply to nonprofit organizations receiving funds at issue here. The vaccine organization that you mentioned as well seems to be particularly unlikely to bring into play the considerations that motivated Congress to require the anti-prostitution and sex trafficking pledge, because they're not operating in the field; they're simply doing research on vaccines. But I don't take.
Yeah, it seems to me that these organizations are doing the same thing. But let me ask you my second question, and it is: may a pledge taker, say you're right, and these foreign entities have to take the pledge, may they nonetheless work with prostitutes to encourage the prostitutes to take preventative measures that will advance
So she's
control
going
of
to the
AIDS.
practical effect of the thing. That's
The answer to
interesting.
that question.
Can they do that? Can they say, all right, we'll take the pledge, but we're going to work with prostitutes to make sure that they use preventative devices?
Absolutely, they can, Justice Ginsburg, and we encourage that. That goes back to a point I was going to make earlier, which is the pledge that's required by the statute only requires one affirmative speech act, and that is submitting to USAID with the grant agreement a policy opposing prostitution and sex trafficking. But there's no requirement that foreign entities that make that that make that pledge shout it from the mountaintops or get into anybody's face about it. They are completely free to and encouraged to work with prostitutes and victims of sex trafficking to prevent HIV/AIDS.
So that's pretty interesting.
Indeed,
so this guy is saying that it's a formalism without any effect,
and many other
which seems like a very odd thing to argue for the U.S. government. It's like you can part of your grant application make a pledge that you have no intention of actually following through on. So basically, there's no penalty for lying to the federal government, according to this guy. It's an interesting position to take for the U.S. government. Yeah. We pledge that we totally oppose it, and then 5 seconds later, we're totally not doing anything responsive to that. That seems like a very odd position to take.
The amicus brief filed in this court's case last time by the Coalition Against Trafficking in Women, which made the point that many prostitutes and victims of sex trafficking are themselves opposed to prostitution and sex
it appears
trafficking.
that they've decided that for questioning that every justice gets a set amount of time, and they speak in order of seniority.
Just following up on that question.
Because this is in order of seniority.
Some would.
So it seems like they've decided that for the purposes of this, that every justice gets so much time to ask questions.
This court said,
as a way to figure out who speaks when.
Takes money for the government and uses it
and I guess Justice Thomas has decided that he wants to use his time.
Prostitutes as part of their effort.
Okay.
And says use.
So I guess this is a whole new era of Supreme Court. Justice Thomas,
and if at the same
time, verbally active years.
But we against prostitution.
Okay. This is a thing that's happening now.
We're against it. It's terrible. Well, the prostitutes will think they're hypocrites, or maybe worse, and will be suspicious. That was their reasoning last time. Now, how does that change one iota in terms of their rights, which we said they had, the major organizations?
Well, we know which way Justice Breyer is going to be deciding this issue.
How does that change one iota?
Sometimes questions are for rhetorical effect. That question is not for rhetorical effect.
They give the money
that
to a
question is, here is how I
India
am going to vote.
Who is associated with them.
Yeah,
and
so we know which way Justice Breyer is going to vote.
Exactly the same thing.
Justice Breyer is a vote to affirm. That's for damn sure.
Since the foreign workers
that's one
are identified by name, mission, logo with the domestic workers, how does it interfere one whit less if we accept your argument? They will be seen, domestic as well as the foreign ones, as hypocrites or worse, interfering with their mission. If we accepted that argument before, why don't we accept it now?
So a couple of quick responses, Justice Breyer. I don't think that the court did base its prior decision on that particular concern. I think it based its decision on the First Amendment rights of the U.S. entities that were receiving the funds. And so the principal difference between the case last time and the case this time is not that the entities are interacting with prostitutes in any different manner. It's that the entities that are now subject to the funding condition lack constitutional rights under deeply established, the deeply established principle that foreign entities abroad don't exercise constitutional rights and therefore can be subject to greater speech restrictions than U.S. entities at home. Now, I want to reiterate that I think the concerns you have raised, while legitimate, are not borne out in practice because the policy requirement, whether applied in the past to domestic groups or now to foreign groups, does not require them to tell prostitutes that they oppose prostitution or to do anything affirmative beyond agreeing to be opposed to prostitution and sex trafficking in the letter. And we're fortunate to have a 17-year track record to look at here. The foreign entities have from the very beginning.
Yeah, this is a very strange position for the U.S. government to take.
The district court's injunction
it's a very strange position to take. It's like you have to make a pledge that you oppose prostitution and sex trafficking, but you don't have to do anything after that. So it's kabuki. So that's very weird. It's like, yes, on your grant application you have to say that you oppose this, but you don't have to like say that in any way. You don't have to put it on your website. You don't have to do anything in your literature. You can do things in practice that are completely contradicted by this pledge. So the pledge is completely meaningless. So what's the point of the pledge? I don't know. It's a very odd position for the U.S. government to take. Yes, you can apply for a grant and pledge that you oppose prostitution and sex trafficking, But you don't
it
have to. But
depends.
that's
What
the
we
only
look at
compelled
is whether
speech is on the
the
grant
recipient
application.
of
On
the
the grant
funds, the
application,
entity subject
you
to
have
the
to say it,
condition,
which
has
is only
First
going to the
Amendment
U.S.
rights
government.
or
So
not.
only the U.S.
And we
government would
think
know
that turns
about it
on whether they're a
or
U.S.
not.
entity or a foreign entity.
And once you receive the money, you can
what do you
in your
understand
brochures
to be the meaning
presumably
of
say,
legally separate
we love
or
prostitution
legally
and sex
distinct?
trafficking. We think it's the
And how would
greatest
that
thing,
apply
and that doesn't
where
present a problem.
the U.S. entity
So
is
it's a
nonprofit
kabuki requirement.
corporation, a trust,
So that's a very
or
weird position for the U.S. government to take.
an unincorporated association?
Yeah, you have to
for
say it,
any
but
of
it doesn't
those,
matter.
And in the situation where the foreign entity is organized,
That's a very odd position for me.
So the sort of difficult questions about how to parse incorporation have really not arisen in this case, because I think respondents and the foreign entities at issue are clearly legally separate in the way that matters for the funding program, which is to say they've applied separately for different grants. And so the easiest way to answer the question, I think, is that when a U.S. entity applies for a grant as its own entity, it's not subject to the policy requirement. When a foreign entity applies for a separate grant, distinct from any affiliation it might have with a U.S. entity, then it is subject to the policy requirement.
I know. I do take note. I do take note that, as you would expect, it is illegal to lie to the U.S. government. 18 U.S.C. 1001 for starters, but it doesn't necessarily end there. It is illegal to lie to the U.S. government, but apparently, according to the Solicitor General or the Assistant to the Solicitor General, whoever this guy is,
the condition
according to this guy, that's totally okay here. You can totally say on the grant application, yeah, we oppose this, and then do absolutely nothing to oppose it in any way.
What is legally separate from what foreign entity is legally separate from?
That's weird.
A U.S. trust.
I have to confess, Justice Alito, we haven't confronted the trust question, so I don't have a ready answer for that. I think that in the 17-year history of the program, though, there really hasn't been any difficulty in telling apart foreign organizations from domestic organizations. We're happy to take a further look at the trust hypothetical, but it's one that just hasn't arisen.
Well, is that because until recently, the government's test was not whether it was a legally separate entity, but a multi-factor test under the regulation to which Justice Thomas referred?
No, with respect, Justice Alito, that's not and hasn't been our position. From the outset, the government has applied the policy requirement to foreign entities abroad. And it turns out, as a result of injunctions, for almost an entire period, the government has not applied the policy requirement to domestic entities. The regulations.
Justice Sotomayor?
Sotomayor.
Justice Sotomayor?
I am sorry, Chief. Did it again. Mr. Michel? The long and the short of this is that a domestic agency that does not want to adopt a policy of being opposed to abortion, but who is willing to not support it in a program, they can't receive funds unless they affiliate with someone who will make the statement for them, correct?
I don't think so, Justice Sotomayor. A U.S. entity that opposes prostitution and sex trafficking, which is the only requirement at issue in this case, can still receive funds as a result of this court's prior decision, and they can use those funds abroad without contracting or otherwise working through affiliates.
But the domestic corporation who doesn't want to speak the government's message but does want to do the program can't unless it finds a affiliate who will speak the government's message.
With respect, Justice Sotomayor, I think that was the issue in the case last time, but that's no longer true. Yeah.
Exactly. And the last time when you sought for cert before us, you said it was tantamount or amounting to a facial challenge. If we read our prior decision as basically facially addressing the restriction, do you win?
I think if you read it as truly facially invalidating the statute, then no, we couldn't win. But for the reason,
I move on to another question. In
Well, I
Hollywood,
think we know where Justice Sotomayor is sitting,
recognize
too.
that a closely held corporation
Justice Sotomayor sounds like a
at
vote to
least
affirm,
could be
too.
viewed as expressing the religious beliefs of its owner, a person independent legally. In Hurley, we said that parade organizers could be identified by the people who marched in their parade. And similarly, in Reagan, we said that an entity could speak through an affiliate who would be recognized as itself because it could then do lobbying that Reagan couldn't do under the government program. So these cases seem to suggest to me that at least in the First Amendment context, let's put aside any other context, but in the First Amendment context, we are less concerned with corporate formalities than we are with imputation or perception. And to the extent that these corporations are closely affiliated, and presuming, I know you said before that you don't think there's enough in the record. We can deal with that separately. But presuming that the public does perceive these entities as one, then why wouldn't the First Amendment apply to the inability of the domestic corporations to receive funds and partner with a closely affiliated foreign entity in implementing the program?
Justice Sotomayor, a couple of points. I think Hurley and some of the other cases you cited all depend on the predicate of a forced affiliation between the two groups. In Hurley, it was the parade organizers and the group that wanted to join the parade. Here, however, and this is a response, I think, to the last part of your question, no one is forcing the domestic entity to affiliate with a foreign entity. The domestic entity has a choice to take the money and use it itself.
Yeah, I do see Sotomayor's point, and I think there's a lot of validity to it. She's like, we could decide this on the formalism of the corporate structure. So we could decide it on that basis. Like, again, like if you're formally affiliated, that's one thing, or loosely affiliated, it's another thing. But then, of course, that just creates this illegal fiction where a domestic corporation can create an unaffiliated organization to speak for it. And then, like, what's the point of that? So looking to the formalism of the corporate structure as a way to solve this problem does have a lack of appeal. So I understand Sotomayor's point.
As opposed to the imputation, and in Hurley, as Justice Sotomayor pointed out. Can you speak to that a little bit further for me, please?
Sure. I think that the critical point, as I said, the reason to follow corporate separation here is that that's how the grant program is organized. And this court, you're right, in Hurley, where there was a forced association, the court held that attribution matters. But in every one of the court's funding condition cases, the court has looked to the effect on the recipient of the funds itself. And here, respondents and the foreign entities are making a conscious choice to apply for separate grants as separate entities and to be subject to separate conditions.
I think the argument is goes a little bit beyond the forced nature of the association to the concern about chilling of speech. Can you speak to that? First Amendment doesn't care just about protecting speech. It also is concerned about avoiding chilling of speech.
I think you're of course right about that, but I simply don't see any chilling of speech here, given that as a result of this court's prior decision, the domestic entities.
Well, I mean, there's a little chilling of speech because one of the First Amendment protections is a right of association,
and they're also
right?
free to make a different choice, which
freedom
is
of association. So there is a First Amendment interest in being able to associate. There's also a freedom of speach component to that. We agree with this other organization.
But even in that instance,
so there is a First Amendment interest there
to use their own speech.
So the separation of the First Amendment interest from the domestic organization and the international organization is an interesting
sex trafficking. I
elements.
think ultimately what respondents are asking for is a sort of right to optimal message management, which is simply not what the First Amendment protects. If you look at cases like Rumsfeld versus Fair, the court explains that the law schools in that case might well be concerned about misattribution of their position on letting military recruiters onto campus, and yet that concern alone was not a reason to find an unconstitutional conditions violation. And likewise, in the court's other funding cases, like Rust, for example, and Regan, the entities were ultimately not allowed to operate in their preferred manner. The abortion providers, for instance, in Rust, certainly didn't want to have to separate their speech in the way that they did.
Yeah,
but the
Phoenix,
court found that it was
you basically asked the question, well, at least one of them.
And the executive
That's one of the
branch
questions
to
that's
require them
embedded
to
in here.
separate that speech
How the
because
freedom
they
of
still
association,
had an
the
open
fact that the
channel
foreign and
to
domestic
express
entities are
their
basically the
First
same
Amendment
entity
views. And after this
that you can
court's
associate
prior
with yourself
decision,
with. I mean, that's essentially one of the
respondents
operative
clearly
questions
have an
here.
open channel to
So,
express their views without chilling
I'll let you
and
know in a
without
couple
having to
months
give
when
up
the
the
Supreme
money.
Court tells me the answer.
Thank you.
Thank you, counsel. Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Michel. I'm interested in the implications of our decision in this case. In particular, if the government were to lose this case, would any other programs or statutes be invalidated or called into question by such a decision?
Well, Justice Kavanaugh, I think that there would be real concerns about that. Of course, I'm not here to give up any other statutes, but I do think the gravamen of respondents' position is that they and their foreign entities that they've chosen to keep separate should somehow be treated as some kind of single global unified entity. And if that is the theory that they're operating under, I do think it would call into question a number of different statutory and administrative regulations of foreign speech that likely
Someone asked, do you have a reason for recusal of the justice in this case? I can take a stab at it. I can take a stab at the reason why. I mean, Kagan, before she became Supreme Court Justice, was Solicitor General, and there was this case previously existed in its prior form in 2012, 2013. So something like that. So my guess would be that Kagan was directly involved with the case that was previously decided. So she's recused because she was directly involved in this particular case. Seems logical.
Entities abroad on certain policy objectives, such as opposing terrorism or supporting women's rights or opposing apartheid, or in the case of the Mexico City policy, taking certain positions on abortion. And those content-based, viewpoint-based speech restrictions might not be permissible in the United States, and domestic entities who were able to confer or unite with their foreign bodies, foreign entities to challenge those would, I think, create considerable risk of disturbing long-settled laws.
One other question. Has the program with respect to U.S. domestic organizations suffered any problems or been any less successful since this court's decision in 2013, as far as you're aware?
Not at all. The
program, so Kagan might have been Solicitor General
to both domestic
at some
and
point
foreign
in that.
recipients of funds has, as I said at the outset, truly been one of the historic successes in the history of U.S. foreign aid. And I think we do have sort of the controlled experiment over the last 15 years as a result of injunctions in the first case and stays of the injunction in this case, that the current status quo, whereby U.S. entities are not subject to the policy requirement, but foreign entities are subject to the policy requirement, has been the background law in place for about 15 years, and that has neither set back the extraordinary success of the program nor created, as Judge Straub noted in his powerful dissent, any actual evidence of hypocrisy or confusion of message for respondents themselves.
Mr. Michel, take a minute to wrap up, please.
Thank you, Mr. Chief Justice. I do think this case ultimately, in its current iteration, can be resolved on a straightforward basis that respondents themselves long accepted, and that's that the policy condition is a permissible exercise of Congress's core spending power as applied to foreign recipients that lack First Amendment rights, but not as to domestic recipients that have First Amendment rights. And although respondents have broadened their position, they had it right the first time, and nothing supports the bootstrapping that they've requested.
Thank you, counsel.
Yeah, I think that's probably ultimately the right argument. Yeah, the
Chief
foreign
Justice,
entities don't
and
have
may it
First
please
Amendment
the Court.
protection, so
The undisputed
their
record
affiliation with
shows
the
that the
domestic
U.S.
entity is
respondents
irrelevant unless
themselves
they're like a
suffer
formal
First Amendment
subsidiary or
harms
something
when the
like that.
policy
They're
requirement
formal
is imposed
subsidiary
on their foreign
or
affiliates.
formal, like,
Respondents and
but
their
if they're
affiliates
separated,
share
then
a
no.
name,
Even if it's a legal
brand,
fiction
logo,
for
mission,
the
and voice.
separation,
They speak as
then,
one, make speech
that's
and
a legal
policy
fiction
decisions
that comes with
together,
consequences
and are indistinguishable to
too.
the
So
public.
yeah, it works for me.
As a result, the First Amendment rights of U.S. respondents are violated here in two ways. First, by a speech compulsion that is attributed to them. When CARE in Kenya takes the pledge, its affirmation of belief is attributed to CARE in the United States, thus putting words in the mouth of the U.S. entity. The second violation is from a speech restriction under regulations that prohibit any CARE entity from
This is very,
contradicting
very
the
live,
pledge,
DJ. Yes.
even on its own time and
This is
dime,
extremely
thus making it
all the way
impossible for
live.
CARE U.S. to disavow CARE Kenya's pledge without engaging in doublespeak and losing U.S. funding for its global network. The government says the burden is on respondents to avoid such harms by applying for funding themselves, severing their connections to
Which is
affiliates,
incidentally
or
why we're doing it
disavowing
at this
the pledge.
time, because
But
it's
this
live.
has it backward. When a statute violates the First Amendment, the burden is on the government, not the Speaker, to give First Amendment freedoms the necessary breathing space. Plus, the government's proposal
I have no
all
idea if
fail in
Open
practice.
Society is affiliated with George
Asking
Soros. You'd have to do your
apply
own
for
research on
funds
that one.
Ignores that they must work through local affiliates in places where local laws
Not that I care
or
personally
the US
either way, because the First
own
Amendment
funding
law
criteria
analysis
require it.
is not
Severing
going to turn
ties
on
with
that for me.
affiliates would destroy
You
their
know, George
organization.
Soros has exactly the
Opposing such a
same
choice
First Amendment rights
demonstrates how the
as anyone
government
else.
continues to use its
And you have the
vast
First Amendment right to
spending
criticize
power
George Soros.
to coerce respondents' fealty. Disclaimers also fail because, as this court recognized in 2013, U.S. respondents cannot credibly disavow the speech of their own clearly identified affiliates. The injunction affords respondents complete relief from these violations and should be upheld.
Counsel, can your client compel what the foreign affiliates say on this question?
We represent several different organizations here, as Your Honor knows. And I think it is correct as a factual matter that in every case, the U.S. organization effectively can veto the speech of a foreign organization on these issues. They do speak together, they make their speech choices together, but the U.S. entities here, as a practical matter, typically control that speech.
Can you give me a citation of the record where I can look to find that? Because I thought that by saying that there wasn't a formal affiliation, but the organizations share the logo and the name and so forth, that there was some absence of control. And in fact, that's what the foreign governments, for example, were insisting on.
I think Your Honor is correct that there is, as a legal matter, there may be the absence of control in some cases, but in every case, there is practical control. I think the best citations to the record would be for CARE would be at JA 389, which talks about how the CARE entity speaks with a single global voice. And then I think importantly, JA 436 through 445, which discusses CARE US's ownership of the brand and licenses on the brand, which is, in that case, legal control to dictate what occurs under that brand.
Thank you for that, counsel. You used the phrase practical control, and I just wonder precisely what your test for that would be.
I think the right test here is the risk of attribution. As this court recognized in 2013, there can be a risk of attribution across corporate lines where the entities in question are so clearly identified as they are here. I think the practical control point is even stronger when those entities speak together with one voice and make their speech and policy decisions together.
And Peter asks, I'm still stuck on this, why the speech is
counsel.
considered compelled. Can't speech be required for all
Yes,
government
thank you,
grants?
Chief Justice.
There is this unconstitutional
Did you have an opportunity
conditions
in
doctrine
the lower
which basically says the government cannot require you to do certain things as an operation of giving money or otherwise. So, to give the clearest example possible, it's like, the government doesn't have to give out welfare, but if it gave out welfare, it can't say as a condition of getting just general welfare, you give up all your Fourth Amendment rights, and we can enter your home at any time.
Judge Marrero gave the
parties
an
we can pull you over and raid your house and blah blah blah. It can't. And also, by the way, you can't be a member of
and to explain to him the relationship between these entities. I think here what's important is there is no dispute about the relationships here.
They can't do that. So there is an unconstitutional.
There's no dispute that they share a name,
unconstitutional
brand,
conditions
logo,
doctrine.
mission, and
the
voice.
Government can't require you to give up
critically
fundamental
here,
liberties in order to get certain benefits. So that was the doctrinal
this case with the
view
government.
there.
We provided extensive factual information to the government.
Someone clue in midnight over here as to what the case is about, please.
And we offered to stipulate to a definition. And
yes, railway hacker parole conditions. Yes,
that effort by us.
Right.
But we did make a full effort in the district court and then separately with the government to come to terms on this issue.
Well,
I guess the principle there is that you were already convicted, right? So like parole is relief from a conviction that you already have. So we're lessening the burden on you.
Absolutely,
right?
I think
we're already entitled. We're already entitled to keep you in jail.
A global network.
So if we're giving you parole and we're saying as a condition of that parole, we can search your house. Well, we could have already searched your house before. Before your house was your jail cell.
We're talking about
so
attribution by
that's
the
different
observer,
because we're lessening a penalty that you've gotten as a result of due process. Versus,
Sotomayor,
it's not quite
mentioned.
It's not quite the same rationale.
That Justices Alito and Breyer previously discussed. A long line of cases recognize that there can be attribution across corporate lines, especially with
Peter asked about the speed limits in case of the federal government. Even then, you don't have the unconstitutional conditions. Well, they don't use that language. They don't use unconstitutional conditions language, but they do talk about coercive effect of federal government, even in that situation. And the case on point for that is South Dakota versus Dole. South Dakota versus Dole talks about the drinking age of 21. The reason that every state has a drinking age of 21 is because the federal government has said, if you don't do that, we're going to take away 10% of your federal highway funds. And South Dakota versus Dole analyzed that condition. And South Dakota versus Dole said, yes, you can make it conditional, but not to a coercive effect. The Supreme Court said that 10% was not a coercive effect. So there's some number higher than 10%, and the Supreme Court seemed to be hinting that 10% was kind of at the upper limit of what's possible. But there is some limit where even conditions as applied to states would be deemed unduly coercive. So if they said 100%, it wouldn't fly. So that it was a 10% was deemed to be okay. But there's some limit there that is unduly coercive. So they don't use the unconstitutional conditions analysis because you're not talking about individual rights, where you're talking about a constitutional guarantee. In the case of like imposing on a state, you're talking about federalism issues. So it's a different kind of analysis. But even then, they do talk about coercion. There is a limit. So even then, you would have that kind of analysis.
And so the categories of injuries are twofold.
Yes, it is an interesting fine line. That's a lot of Supreme Court decisions that are about fine lines.
For these U.S. organizations.
That's what we do in the big leagues, baby. This is big leagues time. We do fine lines for days, baby, 4 days. And that's why I was saying, like, this case could turn on very fine lines. It could turn on formalism. Right? It could be like it turns on formalism of corporate structure. So it would be okay if it's just a random affiliation, but not okay if it's a subsidiary, a wholly owned subsidiary, and then like how close is that affiliation to be? So yeah, it could turn on some really fine lines. Welcome to constitutional law, man. It can get complicated. As Tim Pool might say, it's complicated. Except, unlike what Tom Pool is usually talking about, it's extremely, unbelievably complicated. all the
That
complicated.
pledge, by taken by the foreign
People who
entity,
study this all their
is
lives,
the price
it's complicated.
for receiving
I studied this
U.S.
I've studied
dollars.
this for the last 13 years,
The foreign
and I'm telling you,
organizations
it's complicated in my
continue
own
to
head
work with prostitutes.
because you're
They have
facing
just
like
made
really
a
tough
statement
issues,
that on the ground
you
means
know,
nothing.
which is also incidentally, I know this is a little off
Justice
point,
Ginsburg, I think
but this is
this
also
court
like
had it
incidentally
exactly
where
right in
people talk about the Second
2013
Amendment,
when it
and I've seen this happen in my own
recognized
stream and also in Viva's stream,
that,
when people
an
talk about the Second Amendment
organization
and they just
cannot
write
both
"shall
avow
not
the
be
government's
infringed" in all
viewpoint
caps.
and then
I'm like,
turn
that
around and assert a
that
contrary
really does
belief
nothing to
or
answer
even
any of the
claim
questions
neutrality
at all
without
in any way.
appearing
Just
hypocritical
writing "shall
and
not be
without
infringed" in all
appearing to
caps
engage in double
does
speak.
nothing
And the problem
to
here, of
answer the
course,
legal
is that the
questions.
entities are indistinguishable
You're not even
and
trying.
they speak as one.
It's
so
it's
focusing
way
on the
more complicated than
corporate
that.
difference
Way
is a
more
mistake.
complicated.
After
All the
it
complicated.
would
Yeah.
be odd that the international operating arms of these U.S.
Yeah,
organizations
I don't
are
know,
treated
Mark.
differently based on
I
whether
don't know
they
what the deal
operate
with
through
Justice Thomas
branch
asking questions
offices
is.
or
Apparently,
through
they've
separate
decided, as a
corporations.
matter of
And in
process,
fact, what
which I
what
guess
is
is as
wrong
reasonable a
with the
way to
government's
do it as
view
anything, because
that
we're making it
this
up
is
as we
all
go
by
along.
choice
The Supreme Court is
is
making it
that
up as
there
we
are
go
certain
along, because
jurisdictions
we've never done this before.
where local
So apparently, what the
law
Supreme
and
Court has
even the
decided
U.S.
to do
government's own
is
funding
they're going to give each
criteria
justice a set amount of
require
time,
these U.S. respondents
presumably
to
about
work
4
through local
minutes, because
affiliates.
that's what 30
And
divided by
so
9 is roughly, right?
we're
So each
caught
justice gets about
unable
4
to
minutes
disavow, credibly
to ask
disavow
questions,
the speech
and they're
of
going to
an
go in
entity
the
that
order of
looks
seniority.
just like our client
And Justice
speaks as
Thomas
one
has
with our
apparently
client.
decided to use his
Let me ask
4
you a
minute
question,
allocation
an argument that
in
you
this
didn't
and
make.
the last
You
case.
concede that a
I don't know
foreign
why,
entity has no
but
First Amendment
you know,
rights.
that's what's happening.
What about the
I don't know what to
First
tell you,
Amendment
man. That's
obligations
we are making
of
the procedure up
US?
as we go along. We're making it up. So
U.S. government?
okay.
For example, we can say the Eighth Amendment doesn't apply abroad, but does that mean that a U.S. government?
Yeah, I know. I know what happened last night on Viva's
abroad
stream. I did call it out in the
to
chat.
torture people?
I'm like that. I said to the guys, like that does nothing to answer the questions
Justice Ginsburg,
in any way.
I think
It does nothing to answer the questions.
Sorry, I'm sorry
Just
for
writing
interrupting.
"shall not be infringed" in
And
all
I'm
caps
asking whether
doesn't
these
tell me
U.S.
anything.
actors have an obligation to conform
You know?
their conduct.
It's like someone asked me in chat one time, "What does the word infringed mean?" I'm like, that
The first
is a
response
very
is,
good question.
I don't want the court
Let
to
me
think
point
that
you
we're
to,
trying
like,
to export
all the
First
law review
Amendment.
articles,
That's not
trying to
what we're
figure that
trying
out.
to do. We're just trying to afford
Yeah.
complete relief
That's
to
a good
U.S.
question.
organizations that have First Amendment rights
Writing the
here.
word infringed
But
in all
to your
caps does
Honor's
not
good
tell me
question,
anything.
I think in a system with a limited
It's
government
not helpful.
and a constitution that includes a Bill of Rights, I think there is a fair question about the extent to which the U.S. government can go beyond what it's authorized to do in the Constitution with respect to speech. I guess the other
Was that
point
you,
I would
Black Horse
add
Cavalry? Well,
is that even these clearly identified
writing it in all caps still
affiliates
is not helpful.
overseas,
Oh, no, you asked me what does
I
infringed mean?
think the
Oh,
government
yeah, well,
would
that's a very good
concede
question. It's an extremely
have
good
First
question.
Amendment rights
It's just a
when
question
they,
that I can't readily answer.
act here in the United
Because
States, as they
I don't
often
know.
do when they come here for meetings,
Because
or to
there's
publish
not a lot of
papers,
case law
or to
telling me.
participate in conferences.
Like, if you ask me what does it mean to
And
abridge the First
problem
Amendment,
with
I'm
the
like,
pledge
I
requirement,
can
of
help you.
course, is
I
that
got
it
this.
binds these
I got this.
organizations
Because I got like 70
forever and
years
for
or
all
80 years of
purposes.
case law
Thank
on the
you,
First
counsel.
Amendment describing
Yes.
what are and are not
Justice
abridgments
Breyer?
of the First Amendment. So if you're like, what does it mean to abridge the
It
First
seems
Amendment?
to me the government
I can help you. Here's
is
what it
prepared to
means.
concede
Here's
that
like,
you,
I can
the
like lay
CARE
out the First
USA,
Amendment, you know, in brief,
doesn't have to
in about
doesn't
10
have to
minutes,
oppose
maybe a little longer than
prostitution.
that, to explain it.
But they
So
say
like,
the First
here's
Amendment
how that
doesn't
works.
prevent them
But you asked me,
from
what does
telling
infringement mean in the Second
CARE
Amendment? I was like, I don't
India.
know.
It did
Because I don't have any case law telling me.
So
I have no
why
idea.
Don't you simply write a grant to get all the money
I
yourself,
got
and
nothing.
then you give it to CARE.
Mark gives me
India.
$10. Thank you.
Why doesn't that
Thanks for
work?
the compelling live streams, Blackleaf. You are most welcome.
The
Yes.
problem with that, Your Honor, is that according to the government, the policy requirement still binds the U.S. organization in the following way. If CARE U.S. gets the money and subgrants to CARE India, it must
Yeah, that
carry
can't
the
can't
burden
possibly
of
be
the
correct.
government in
That
the
all
sense
laws
of
are infringement.
imposing the
It
policy
can't possibly
requirement
be
on its own
correct because if
affiliate
all laws
and police compliance
are an infringement,
with
then
the
all
policy
laws
requirement,
are a
not
abridgment
just with
in the
respect
First
to the
Amendment
speech and
context, and
activities
we know
of
that's
its
not
foreign
true.
affiliate, but also with respect to
If
itself,
all laws in the
lest
Second
it
Amendment
violate
context
the
are
regulations
infringements,
which
then
Where
all
do I
laws in the
find
First
in the
Amendment
brief
context
or
are
in the
abridgments,
record
but
just
they're
what
not.
you said?
So it
Because
can't
seems to
be,
me
it
just
can't,
what you
it
said
cannot be true
shows that
that
this
all
case
laws
is
are infringements
100%
within the
about
meaning of the
the
Second Amendment. It
rights
can't possibly
of
be
an
correct.
American company, the parent. And the question is, can they forbid, can the government require them to forbid one channel of communicating the message? Can it control what they say in that channel? The channel happens to be a channel that goes abroad. I don't know that there's any precedence for the precedent that says they can. I mean, if I got that right, is that clear?
Yes,
It's
I
your
think
truth.
the best citations in the record, Justice Breyer, would be the regulations themselves, JA 248 to 265, and I would direct Your Honor's attention to the discussion, the commentary of 45 CFR 89.3, and that's at JA 256.
Barney asks about foreign policy, what would happen if the U.S. government demanded a hypocritical term? For example, that citizens of other countries are denied free speech.
Their separation from entities that speak inconsistently, but they even go so far as to say there has to be separation from entities that do not have a policy themselves, suggesting that the government's view is that the U.S. respondent
I'm not sure why the U.S. government would want to, but as a matter of principle, could they?
I also think another place to look in the record is at JA 375 and 390, where the Pathfinder organization
I never thought
talks about U.S.
I mean, presumably the
funding
answer would be
criteria
the same,
require them to work through
because there's no
local
First Amendment
affiliates
guarantee
and locally incorporated
overseas,
entities.
especially as to foreign entities.
Thank you.
So if the U.S. government said,
Justice
we're going to give
Alito,
money to foreign entities, foreign NGOs.
I agreed with your client's position.
We're going to give money to
when
foreign
this case was before
NGOs
us
to do whatever, but as a
previously,
condition,
but
they
what
must
concerns me today is not so
promote
much the
and
immediate
support
impact of a decision in their favor, but
censorship.
where it would lead.
It's not obvious to me how that analysis would work. I never thought about it.
Force Congress either to withhold foreign aid entirely or to allow foreign aid to be used in ways that are contrary to the interests of the people of this country. So let me give you this example. Excuse me. Suppose that the United States provides grants to domestic entities and allows them, excuse me, to make sub-grants to foreign schools for the purpose of promoting education in countries with weak educational systems. And suppose that Congress specifies that any foreign entity that gets a sub-grant must have a policy denouncing terrorist attacks against American civilians. Would that be unconstitutional?
No, it wouldn't be, Your Honor, because that requirement doesn't require the affirmation of a belief and then conformity with that belief and espousing it as one's own. And that's this requirement.
Exactly. The school that gets the money must have a policy denouncing terrorist attacks against American civilians. It's compelled to speak. It doesn't want to make that speech. It is affiliated with an American entity. Why isn't the argument exactly the same in that situation?
I think that there's a problem with germaneness in that case. The requirement there wouldn't be related to the federal program. But to Your Honor's, I think, larger question, this doesn't turn on the particular ideology. I think any ideological commitment, any requirement of an ideological commitment by grantees is problematic for the same reasons as the one here.
Yeah, exactly. That's exactly right. Let me ask you one more question before my time expires.
Yeah, Justice Alito, I think, has it right. I can't see a difference between those two things. I can't see a difference between those two things, but this guy seems to say there are. We are going to give money to foreign entities for healthcare-related reasons, HIV particularly, but healthcare-related reasons, but they have to oppose prostitution. Okay. we're going to give
tell
money
the
to
foreign
people to
entity
promote
you
education,
cannot
but they can't
use,
support
you must have
terrorism.
a policy opposing
I'm having a hard time
prostitution.
splitting the difference
U.S.
between those
entity
two
is
things.
compelled to
I
make
think
a
Justice
statement
Alito's
that it
examples
doesn't
is
want to
pretty
make. Why doesn't the logic of
good.
your argument apply
So
there?
if the one is constitutional,
Well,
the
in
other is
that
presumably
case,
constitutional.
the entity being made to take the pledge is not clearly identified with the U.S. entity, and therefore the pledge of the foreign entity doesn't get attributed back to the U.S. entity, and I think that's a very
The collector
important
asked me, at
difference.
what point did the corporation
Here,
become a living entity?
when
The Constitution
the
was
U.S.
for the people and by the
entity
people.
imposes
Well, as I've
the
said before
requirement
many
on its
times, the idea of corporate
sub-grantee, on its
personhood
clearly
goes
identified
well
foreign
back
affiliate,
into history,
it's as
well
if
back
it's
before the
imposing the pledge requirement on
Constitution.
itself,
The idea of
because
corporate
after all,
personhood as
these
an independent
organizations are
concept.
indistinguishable and
And then
speak
what
with
that
one
does or
voice.
does not encompass, corporations are,
I
of
do
course,
think it's
collections of
important
people.
to make the point
So
that the
there's a
government
First
still has
Amendment interest
very
there
broad
too.
authority to control
So,
what happens with its
you know,
funds,
that's
to
the
put
idea
in
of
place
corporate personhood
policies
goes,
for its programs,
you know, far
and to
back as the
require
concept of the
that
corporation.
grantees
One of the
fulfill
purposes
the
of the
requirements of
corporation
the
was
program in
to
every
separate
respect.
the
This
corporation
particular
legally
requirement is
from
unique. There's no other
the people
requirement
that
like it in
encompass
U.S.
it
law, and I think a decision
structure
for
risk
respondents
differently.
can be very narrow, turning on the facts of this case and the prior ruling of this court, which declared the policy requirement unconstitutional.
Thank you, counsel. Justice Sotomayor.
Citizens United did not give corporations rights as
Counsel,
personhoods. No, that is incorrect. That's an incorrect
there has been
reading
a long
of
history to
Citizens
this
United.
case.
Citizens
I'm not
United
quite
did
sure
not
what
create
the
corporate
relationship
personhood. That is a
is
wrong
of
reading
your
of Citizens
client
United.
to the
Corporate
agency
personhood goes
now.
well
Are your
before
clients
Citizens United.
grant recipients
Corporate
who
personhood is a
currently
concept
receive
that goes
grants,
before the founding of the
who
Constitution.
currently work through
It
their
is not
foreign
a new
affiliates,
idea that
and their
corporations are
foreign
legally
affiliates have
distinct
not
entities.
taken this pledge?
The idea of corporate
Or
personhood goes well
have
back
they
into
not
history.
received grants and want to work with their foreign affiliates? I'm not quite sure what the status is of what the government's been doing or not doing.
So these organizations are the same organizations that were before the court in 2013, but a smaller group because the rest of the
Barney asks, incitement of violence is not protected by the First Amendment. Terrorism wouldn't be.
networks.
But there's
We
a
now
difference between
are talking
incitement
the entities that were before
and
the court
supporting
in 2013
in general.
that are the
Incitement
large international entities
requires
like
imminence.
CARE and Save the
It
Children
requires something
and
happening
World
right
Vision and
now. It
Pathfinder
requires immediate
that are,
threat. So
the
under
ones
First
with
Amendment law,
their
there's a
own
difference
clearly
between
identified
supporting
affiliates
terrorism
overseas.
in general
And
and
these
supporting
organizations
and
receive
supporting an
money here
imminent
in the United
act.
States and
Or
receive money through
engaging
their locally
in
incorporated
speech
affiliates.
that is integral to criminal
CARE,
conduct. So
which
if
is
you,
the
in
example
general,
we've been using,
say, I support
the
terrorism,
U.S. entity receives
that's legal.
all U.S. grant
Because there's
money
nothing happening right
under
now.
this
You're not
program,
trying to encourage
and
a
then
particular
sub-grants
specific
to its
act.
local affiliate.
You know,
And
trying
so
to
in the
like,
case of CARE,
there's nothing criminal about
it has done that,
supporting terrorism in
under
general
objection.
or
It-
opposing terrorism
it
in general.
asserts
So
that it should be free of this
incitement
policy
requires
requirement. It
something
believes
more
that the
than just
litigation
a
in
statement
2013
terrorism
would
is
have
good
disposed of this issue,
or terrorism is bad.
and it continues to suffer
You know,
these First
it
Amendment
requires something more than
harms
that.
and violations that we've been discussing today.
I'm not sure you've answered my question. They are receiving the funds. Are they subcontracting with affiliates or partnering with affiliates? And are the affiliates making the pledge and they're complaining about the fact that they're forced to do that? Or have they not been, and have they not been policing the foreign affiliates and the government's now threatening to take away the funding?
Well, it's a little bit of both, Your Honor. Let me explain. They are receiving the funds, and they are imposing
For the philosophy on the difference, I'd go to Whitney versus California Justice Brandeis's concurring decision because I think it's brilliant and expresses this idea better than anyone probably ever. But to paraphrase Justice Brandeis, because I don't think I can quote it chapter and verse, but to paraphrase what he said, if there be time through the processes of debate
there was a disagreement in the district court
address
about the
the
proper
evils
scope of,
of bad
injunctive
speech, then the cure is
the
more
respondents
speech, not
wanted
enforced
broader
silence.
relief to include
So
sub-grantees,
if someone
and
is
the government
saying
objected on the
terrorism
grounds
is
that those
good,
facts were not
we
yet
should have
known,
terrorism,
and the
then
facts now
unless
are
there's a
known,
threat
that
right
was
now,
fully
the
12
cure
years
to that
ago.
problem
The facts are
is
known,
other people
the
engaging
record
in
is
speech
developed, the
and
district
illustrating
court
why
entered
it's
its
bad.
findings, and I I think there's no dispute
So
about the
that
nature of the
incitement
relationship
requires
now.
something more
And
than
so are
merely
they
a
threatening
general
to take
view
away the
of
funding? Why?
it would be good to rob
They
stores.
are
It would
now
be good
saying
to
that the
break
policy
into stores
requirement
and
will
steal
be
their
enforced
stuff.
as
It would be
against
good
the
to
clearly identified foreign
whatever.
affiliates of the U.S.
It requires something more
respondents
than that.
because they say those organizations have no First Amendment rights. We argue that this isn't about any rights of the foreign organizations. It's about the First Amendment
Counsel,
rights.
I'm sorry
Yes.
for interrupting, but if the foreign affiliates have made the policy statement, so they've done what the government wants.
Have I already covered Citizens United?
Why
Oh,
would
sure,
the
I've covered
government
Citizens
take
United.
the funding away
Yeah, there's a couple
from
videos
you
on my channel
or
about it.
them?
Citizens United. I've covered it a couple times.
We object to that.
So yeah, there's videos. I covered it
policy
relatively
requirement.
recently
We
too,
don't
like a
want
month
to
or
have
two
to
ago.
impose it on our
Covered
clearly
it
identified affiliates.
pretty extensively, looked
And
at the
it's
case law and
causing
the history
US
of it.
respondents to have
I've
to
definitely talked
engage
about
in
it on my channel.
doublespeak. And if they do that, if they attempt
I think
to
Citizens
disavow
United was correct.
that pledge,
I think
which
Citizens
is
United was
attributed
correctly
to them,
decided.
they will lose their funding for the global network.
Thank you, counsel. Justice Gorsuch?
The one about incitement, I'm not sure which case
Counsel,
you're referring
in
to.
response to Justice Ginsburg and Justice Thomas, you indicated
So if there's a
that the
particular
primary
case you want me to
harm your
cover,
client had suffered
sure, it's $20
is the
for me
risk
to
of
cover any particular
attribution,
case,
mistaken
any
attribution
particular
of the
decision.
foreign affiliate's speech to the domestic entity. And that sounds a bit like an alter ego argument, that the ordinary listener will be confused and attribute the speech of a foreign affiliate to
Whitney versus
domestic
California?
entity.
I don't
Yet
believe
at
I've
the
covered
same
that on
time,
my channel,
I
no.
assume you'd resist any effort to pierce the corporate veil from those foreign entities and impose liability on the domestic entity. So in what respect is it, and when should we attribute speech or actions of the foreign affiliates to the domestic entity? Why would we pierce the corporate veil sometimes, but not all the time?
Your Honor, we don't ask the court to pierce the veil or to treat these entities as alter egos. Rather, we're focused on the unique nature of speech and the way speech can be attributed even when corporate formalities are observed. And I think the right line of case law here is not just this court's decision in 2013 in AOSI, but also cases like Pleasant Grove City v. Samum, Walker v. Texas Division Sons of Confederate Veterans, Pacific Gas and Electric, and as Justice Sotomayor mentioned, the Hurley parade case. All of those cases recognize that legally separate entities or individuals and entities can have speech attributed from one to the other without engaging in any kind of veil piercing or alter ego analysis, which would get the court mired into the corporate formalities, which we don't advocate.
Pierce the veil sounds like an
Rather,
innuendo.
we think a more limited
Maybe.
holding based
It's the
on
language we've used.
the
Pierce the
nature of
corporate
speech
veil. Yeah.
and the First Amendment would suffice.
On that score, what evidence is there that there is this risk of confusion or attribution, given that the domestic entity is free to disavow the statements of any foreign affiliates? Well, it seems to me an empirical question. Do we have any empirics?
Yeah, I think the best evidence is in the record in the unrebutted sworn declarations of these organizations, which talk about how they are perceived in the public health community, the price they are paying in the form of hypocrisy, and the way that they
Thank you for the super
their
chat.
integrity
I'll be happy to
and their
cover that on my
reputation
next
and their
stream.
brand when they're forced to speak out of two sides of their mouth. The
Use pierce the veil as a bad pickup line. I've never tried that
I
one.
understand that harm, counsel. I'm sorry to interrupt, but I understand the harm that people will see the disavowal and will take cognizance of it. But is that the same thing as
what's the
anyone
process of
really
speaking in front of the
thinking
Supreme
that
Court?
domestic entity
Well,
abides by
to
the
make an
government
argument, to be in
restrictions,
front of the
endorses
Supreme
them?
Court, you have to be a member of the Supreme Court's
Anyone
bar.
really think that when they
To be a member of the
when they
Supreme
read
Court's
that?
bar,
Or
you
do they
have
think
to
that
be,
this is a statement
I'm going to
made
quote this
by
slightly
a
wrong,
foreign
but you have
entity
to
in order
be
to offshore U.S.
admitted
dollars
to
that
practice
obviously the
somewhere in the
USAID
United States
itself does
for
not promote
some
or
period
agree
of
with.
time. I
Why
forget
wouldn't that
exactly
be
how
the
long it
natural
is.
reading by the
3 years,
average
5
reader?
years, something like that.
Well, I think
But
when
you have to be
public
admitted to
health
practice in the
organizations
United
take a
States for a
pledge
period of time,
saying that they believe
and then you have
something,
to
I think people take it
have
very
2 members
seriously
of
when
the
they
Supreme Court
say
bar
that they believe
sign off
that
on your application.
HIV/AIDS is transmitted in a
So
certain way, or when they say they believe
that's what I did.
that prostitution should be dealt with in a way
And then I
that
went there in person. I
stops
got
the spread
sworn
of the
in
disease.
person,
People listen to them.
which
The
was pretty
reason they're so
badass.
effective
You didn't have to be, you know, you could just,
Counsel, I
you know,
accept that
they'll
again.
do it on
That's
paper.
not really quite my
I was like,
question.
I'll do it in person.
Couldn't
That's
a
pretty
reasonable
awesome.
person hold in his or her mind two things? One, the foreign entity believes X. Two, the domestic entity does not believe X.
Yeah, the strange paper sizes.
Well,
yeah.
Your Honor, I think
Well, no,
that
that's
falls apart when the
not for the
organization
application to be a member of the
speaks with
bar.
one voice,
That
as
one is
these
just like 8.5
organizations
by
do.
11.
They,
So that piece of
they
paper
have a
isn't
right to
strange,
speak
but
that
for the
way.
actual like
they
briefs
have a right to,
they file,
to
they
join
are in
with
strange
their
paper.
affiliates
I think they
in
suspended the
having
requirement
their,
right now
their common
for
voice and their
because
common
of the
mission.
current situation.
And when they're told
I think
to
under the current
say one
rules
thing and
as
then
they exist
disavow
right
it
at
in
this
another
moment,
breath, I
it's
think
normal
it
paper
undercuts
sizes. Which,
their
you know, I'd just be
reputation
happy
and
if they kept
brand
that
and their
endeavor, but
own
it's
speech.
like,
I think Your Honor
yeah, the
has
normal
exactly
size
right.
is really, the
we
normal
back
rules
then,
on the
counsel,
paper is really weird. It's like
the
23
belief that
copies,
people will always
and they have to be
confuse this as one
6 and
entity,
like
and it's not
6
possible for a
1/4
local
by
chapter of an organization to
something,
have a different view
and
than the national
like 7
organization or
3/8,
the international
and
organization.
they have to be bound a
that people
particular
cannot
way
hold
with
that,
particular color
that
paper.
concept in their heads.
It's
Briefly,
annoying.
counsel?
Yes, briefly, I think the public doesn't know that these are separate corporations. The problem is they are indistinguishable, and they look to the public to be exactly the same. And so it really would be more like Your Honor's case in Masterpiece Cake Shop, making the baker
I'd
say
like
one
to
thing
pierce,
and then
I'd
attempt
like to
to
pierce
disavow
your
it in the
veil.
next breath.
Thank you. Justice
Sure.
Kavanaugh?
Thank you, Chief Justice. Good morning, counsel. I want to clarify first one thing from your colloquy with Justice Ginsburg. You agree, I assume, that unaffiliated foreign entities acting abroad have no constitutional rights under this court's precedents?
We do, Your Honor.
Okay. And then I want to pick up on Justice Alito's concern.
Staples does not have a
about the foreign policy
Supreme
effects
Court
of your
option
approach,
for
and
paper.
I have
No.
a hypothetical as well. Suppose the U.S. government wants to fund foreign NGOs that support peace in the Middle East, but only if the
Ginsburg
NGOs
talked.
explicitly recognize
She talked earlier because we're doing
Israel
an
as a
order of
legitimate
seniority.
state. Are you saying the U.S. can't impose that kind of speech restriction on foreign NGOs that are affiliated with U.S. organizations?
I think that's a harder case because I don't hear that as requiring affirmation of a belief. Rather, it's in recognizing a fact that the U.S. has established a certain diplomatic relationship with Israel, and the U.S. government gets to say what that relationship is for the United States. I don't think that's making the entities espouse that view as their own, and so I think that's different. I think that would be acceptable.
Yeah, they're doing it in order
That
of
would be
seniority.
acceptable in your view.
And Ginsburg is third in order of seniority.
I think it would be.
Okay.
So, there you go.
And then the government says that your position would unleash foreign affiliates of U.S. corporations to pump money into the U.S. election process. And I wanted to give you a chance to respond to that claim, which was in the government's reply brief and then repeated here today.
Yeah, I disagree with that. That's a very different case. That is a speech restriction. It is not speech compulsion. And that restriction doesn't apply to the U.S. organizations. And so, and I think this court dealt with that the right way in Citizens United and distinguished the foreign organizations from the U.S. organizations, and it's a different case.
Thank you, counsel.
Well, Alliance's position is that
1
the
minute
foreign
to wrap
affiliates
up,
should
Mr. Boker.
be funded.
Thank you,
in
Your
general.
Honor. Applying the policy requirement to foreign members of these tight-knit international entities fighting HIV/AIDS overseas puts words in the mouths of the U.S. members of those entities. and the program regulations effectively prevent the U.S. members from even disavowing what the foreign members are compelled to say. The injunction should be upheld.
Thank you, counsel. Mr. Michel, 3 minutes for rebuttal.
Yeah, I think James, what we need in the Second Amendment is we need more foundational cases.
Question about facial invalidity.
And the machine gun issue is at best far away from the current case law. What we need, at least in my view, is a foundational right to bear case. We have the foundational right to keep case in Heller and McDonald. What we need is a foundational right to bear case, some right to bear under some circumstances, so that we can build on it. And NYSRPA was potentially that, but then it got nuked. But there are other cases the Supreme Court could take, dealing with some of the restrictions on concealed carry, perhaps.
The holder of the First Amendment right,
or
that is making
I thought the Peruta cases out of California were the most likely. But there's some cases they might take. So you need a foundational right to bear case before you can talk about any of those things.
The U.S. entity has a separate choice to accept Leadership Act funds itself and operate itself in foreign countries without any risk of hypocrisy or a mixed message.
But what's frustrating to the Second Amendment people, and I think rightly so, because I'm frustrated about it, is baby steps doesn't mean it has to be this slow. Because there was no Second Amendment cases like between 2012 and 2020, right? And so like the Supreme Court could be hearing 1, 2, 3, 4, 5 Second Amendment cases every year. They hear like 1 to 3, 1 to 4 First Amendment cases every year.
Right.
The Supreme Court has taken less cases now than historically. The Second Amendment needs the development. So, like, baby steps doesn't mean the Supreme Court needs to be this slow. They should be hearing 1, 2, 3, 4 Second Amendment cases every year and developing this case law. And they should have been doing it for the last 8 years. If they've been hearing 2 to 4 cases every year for the last 8 years, then we'd have somewhere between 16 and 40 Second Amendment cases. And I'd be in a much better position to answer your Second Amendment questions, because I'd have a lot more cases that I could use as a pattern to say, well, here is the pattern, and here's something I can protect against. So that's frustrating to everyone, including myself.
USAID, not to shout it from the mountaintops and not to say anything that will ultimately interfere with the U.S.
Did they decide not to hear any of them, or did they defer them? Did they actually say they weren't going to hear all 10?
I think what happened,
or have they deferred some of those? Did they just not decide, or did they actually decide not to hear all 10?
There's no basis in this court's prior decision or any other source of law for that holding. It would invalidate a provision that Congress has adopted and reauthorized,
they deferred.
and that is working. The decision below should be reversed.
So,
thank you, counsel. The case is submitted.
We'll see how that goes. Okay. Well, that's the end of that case. Cool. So that is the end of that. Interesting, exciting, fun, good case. So I don't really have a particularly strong view on how it's going to come out. I think reverse. But the rationale for reverse is really interesting, because, like, is it going to be like a formalism thing? Because that would be like an easy way to decide it without like deciding like the broader implications of that. So you could simply say that because even though they use the same logo and same name, they're formally unaffiliated, formally unaffiliated. So even though they use the same name and same logo, they're formally unaffiliated. So you could base it on that without adding the broader implications of what if their ties were closer. So that's one way to decide this issue. And if I had to guess, that'd be the basis the Supreme Court's going to decide the issue. Decide it on the narrow grounds. So if I had to guess, I'd say that you're looking at a decision to reverse and say the rationale is that a group that is completely separate foreign, like just a random foreign group that has no ties at all of any variety to a U.S. group, we know that for sure, doesn't have First Amendment rights. So merely sharing the same name, merely sharing the same logo is not enough if you're formally unaffiliated, So presumably that would apply to, I don't know about like what organizations are formally or not like unaffiliated, even if they share the same name and same logo. So it's like, well, there's some sort of affiliation there, at least for the sharing, but otherwise they're like independent actors. So I guess, if I had to predict, I'd predict we know Breyer wants to affirm, we know Sotomayor wants to affirm, Kagan is out for conflict, Ginsburg, who knows. So you're looking at a 5-3 or 6-2 kind of decision, if I had to guess, on the rationale of, because they are formally unaffiliated, then it's okay because foreign entities don't get First Amendment protection, would be what I would think. You definitely have Breyer, you definitely have Sotomayor in dissent, so you definitely have two. Ginsburg, I didn't get a clear sense of where she was sit. I would suspect, given her former affiliation with the ACLU, she's in dissent. So you're looking for 3. So I guess 5-3 is what you're looking for a reversal. Best guess. So yeah, but just a guess. And decided on the narrow grounds of the formal affiliation and leave open the question, but what if they're more closely tied? And what if they're formally affiliated or formally subsidiaries? Leave that question open for another day. That would be a basis to decide that. So if I have to guess, that would be my guess. Decided on those grounds. Decided on the narrow grounds, leave open the questions for another day in terms of other relationships and how close they have to be. And it does make some sense because the foreign entity, or the U.S. entity and foreign entities, have made that decision for the advantages that they incur. And so, like, those comes with some benefits and some drawbacks. And so this is just merely another drawback to that kind of relationship that you'd have to feed into a entire calculation of your formal affiliation. But if you're like a formal subsidiary or you have a closer tie, then maybe that's a different question. But that's how I think this is likely to be resolved. So I'm going to say 5-3 to reverse on traditional conservative liberal lines on the basis of the formal separation of the groups. Same name, same logo, but they're legally distinct, and that legal distinction matters. So, I see that working. Yeah, that's what I see. That's what I see working. Yeah, that's what I see as the best. Yeah. Yeah, the Second Amendment case law may infuriate everyone. It's unclear. You need this is why you need a foundational right to bear case. Because Heller and McDonald simply said, okay, you have a right to keep a handgun in your home. It's pretty narrow, but it's also pretty foundational. So we need the Second Amendment equivalent of that in the right to bear. I'm not sure exactly what that is, but the taking the firearm to the shooting range was pretty good. It's not exactly right to bear, but it's not exactly right to keep either. So it could be a foundational right to bear case. Some of the cases dealing with concealed carry permits might work. But yeah, you need the foundation before you can start talking about the nuances of the Second Amendment law. It's fairly clear that some regulations and some laws will be legal because, again, when you talk about the right to keep and bear arms, at least the way that's understood, is the one that pre-existed. In the same way you talk about the freedom of speech. So the right to keep and bear arms was never absolute. It always had limitations. And so the one that was adopted is the one with those limitations. And so some limitations must be okay because they were never part of the right to keep and bear arms. Remember, the one that pre-existed. We adopt all that baggage for good or worse. So it is not an infringement within the meaning of the Second Amendment if there are regulations that were valid at the time, because they weren't an infringement then. So they're not an infringement now. Whether they were an infringement in some sort of abstract sense is beyond the point. Because the way a originalist would think about this, presumably, the way I would think about this is the right to keep and bear arms is the one that existed. So whatever the scope of that would be is the valid scope. And to the extent that that scope would incur what you might consider an infringement, it's not. because it was just part of the right to keep and bear arms as it was defined at the time. So some regulations must be okay, because there were regulations at the time that were okay. There are regulations at the time that were not an infringement, so they're not an infringement now. That makes sense. And the same kind of thing in the First Amendment analysis. There are abridgments to the First Amendment that are not abridgments to the First Amendment because they weren't abridgments at the time. So defamation is a great example of that, right? Is defamation because, Congress shall make no law abridging the freedom of speech. Okay, so you have to figure out what is an abridgment to the freedom of speech. Is defamation an abridgment to the freedom of speech? Well, you could say, well, free speech would presumably include the right to say what you want, and this is abridgment. But the legal answer to that question is no, because it's the freedom of speech. The freedom of speech. The freedom of speech, as it pre-existed, did not include defamation. So is not considered part of the freedom of speech. So it's not considered an abridgment of the freedom of speech. It's just not part of speech. It wasn't an abridgment then, it's not an abridgment now. So defamation law is perfectly okay because it's not part of the freedom of speech. So it's not an abridgment to the freedom of speech because it wasn't part of freedom of speech as it was defined at the time. And same thing in the Second Amendment law. So is it an infringement to do something? Not if it was at the time. So when you look at laws at the time that were valid, they're still valid because they weren't an infringement on the Second Amendment because they weren't part of the Second Amendment. That's the pre-existing right. So a lot of regulations must be valid because they were valid at the time. So, that's what it seems to me. That's what it seems to me. If you're trying to interpret this in originalist language, trying to understand what the right to keep and bear arms are, the right to keep and bear arms comes with all the baggage for good or ill that it meant at the time. The right to keep and bear arms is the one that existed in 1791 as it would be understood in 1791, encompassing a couple hundred years of common law and restrictions and so forth and so on. So you would look to, the prior 400 years or so of law as guidance for what kind of restrictions would be legal now. If there were valid restrictions at the time, if someone in England put out a restriction in 15 whatever, and it was considered a valid regulation, it's still valid now. Ta-da! So that's, it carries with it all the good and all the ill. It carries with it all that baggage. That's why I like the seven words, the right to keep and bear arms. Those 7 words are doing a lot of weightlifting. They're doing a lot of weightlifting. In the same way, abridging the freedom of speech. Abridging the freedom of speech. Those are 5 words, right? Abridging the freedom of speech is doing a lot of weightlifting. And the Second Amendment, the right to keep and bear arms and shall not be infringed. Doing a lot of weightlifting. That's carrying a lot of meaning in those few words. Which is one of the reasons they use just a few words. Because one of the points of it was to basically all that stuff, we're just adopting it. So how many words do you need? Not a whole lot, as it turns out. So it's all that stuff, great, let's take it all. Great, the right to keep and bear arms. Excellent. What does that mean? Consult about 400 years of case law. We'll get back to you. Good times. That's what I think about when I think about the Second Amendment. And we need case law to define it in the same way we've defined the First Amendment law, or at least parallel. I don't want to say the same, but parallel. Because again, the language in the First Amendment language and the Second Amendment seem very similar to me. It's not identical, of course, but it seems to be talking about the same thing. Abridging the freedom of speech shall not be infringed. Is abridging or infringed stronger language? I don't know. They seem roughly the same. So that language is hinting at, it seems, very similar ideas, if not identical ideas. They might be identical despite the differences in language. Now, they are using 2 different words, so normally you would think there's some difference between them, but they're close. Abridging and infringing, they seem pretty synonymous to my ear. Which is stronger, abridging or infringing? I don't know. They seem pretty close. So I think what we need is the same, at least a similar framework in the Second Amendment law that we do in the First Amendment law. And since we have 80 years of case law in the First Amendment, if we want to reason by analogy to the Second Amendment, then I can give you much easier answers. If I can just say, if I can adopt the entire First Amendment framework and import it on the Second Amendment framework, then I can give you much easier answers about the kind of things that would or would not be valid. Because I'm reasoning by analogy, and I can make parallel constructions between the First Amendment and Second Amendment. Not perfect, but good enough for at least a framework for discussion. So that's sort of how I think about it, Phoenix asks, random shot in the dark, do you think part of the hesitance Second Amendment case might have to do with the groups claiming to be militias? I don't think so, because again, at least to me as an originalist, this is exactly part of the answer to the scope problem. Because what arms mean in the Second Amendment means what it meant in 1791, in the same way that what speech meant what it means in 1791. So you can use the word speech today differently because the language has evolved. But to an originalist, what it means is what it meant in 1791. So whatever you're talking about when you're talking about speech today is a little bit off point when you're talking about the First Amendment, because the First Amendment means what it meant in 1791, not what it might mean if we were talking about speech today, which is probably for good, because some of the left would say, well, hate speech should be excluded, but it's well, it wasn't in 1791, so it isn't now. So I don't think that a group of people calling themselves a militia should have any bearing on the Second Amendment one way or another, because whatever a militia was in 1791 is at least what it is now as far as the Second Amendment concerns. And to the extent a group of people calling themselves is not a militia within the 1791 context, then it's not a militia within the meaning of the Second Amendment, which means that presumably, all else being equal, Congress can do whatever the hell it wants, because it's not what it was talking about in the Second Amendment context. So just because you call yourselves a militia does not make it so, is the short answer to that. So yeah, whatever it meant in 1791 is what it means now. Whatever it didn't mean doesn't mean that now. So yeah, you can call yourselves a militia, but who cares? I don't care what you call yourselves. I call what you are in the Second Amendment. So I don't think it is, quite on point. Yeah, Peter's right that the case law has definitely moved, and for the best. If you go look at the case law before the 1930s or so, the constitutional case law was a lot different, which is one of the reasons that I say anything before 1930s doesn't really count. I say that kind of tongue in cheek because the strict scrutiny analysis that we have now is a lot better than what we used to have. So if you go look at the old case law, they just talk about the government's power to do things, and the case law was not as good as it is now. So I think you should be, at least to my mind, it's a little hesitant because the current frameworks that we have I think are pretty good, and the case law before those frameworks I don't think as good. So I think the frameworks we have now are much better. Yeah, so I think that's what we go. Yeah, so carrying it from the store to your home, I mean, Barney, it's a reasonable question, right? There's no case that says it. I mean, presumably there's some way you have to get to your home, so there must be some implied ability. I mean, unless we're going to have delivery services, which I think would be hilarious. Uber Eats but for guns, that'd be good. But short of that, yeah, there's got to be some implied right to take it to your home, right? So, good times. A Second Amendment law wouldn't have to define militia. You look again, whatever it means is not going to be further defined by law, at least to an originalist. So whatever a militia meant is what it means. So law cannot further modify that, probably by much, if at all, because whatever it meant at the time. Now, you do have to reason by analogy a little bit, because in the same way that you reason by analogy when it comes to modern speech issues, because the First Amendment as such doesn't protect speech on radio or television or Facebook, because those mediums didn't exist. And so it couldn't possibly, right? But what we've done is we've reasoned by analogy to say, well, the First Amendment, because the meaning of it is not being impacted by technology any more than societal development, which is a neat little trick, right? So whatever it meant at the time, and that means that without respect to technology, or at least that's one of the ideas. So we say, well, if Facebook had existed in 1791, would it have applied as the meaning would be understood? So, you have to reason by analogy. And for the same reason you do that in the Second Amendment context, which is like one of the people that say, oh, the only kinds of arms that are protected in this, meaning the Second Amendment, are muskets. First of all, no, because other firearms were known at the time. But even assuming that no other firearms were known at the time, assuming that only muskets were known at the time in 1791, so even accepting that premise, which is factually incorrect, but even accepting that premise, it wouldn't reach the end of the conclusion, because the Second Amendment meant only muskets because they are the only things that existed. Then the First Amendment would mean only pamphlets and books and newspapers and magazines, and wouldn't mean radio and television and Facebook and cell phones and blah 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 blah. That's not how we reason about these things. So the argument that the Second Amendment only applies to muskets, even assuming that was factually correct, which it isn't, doesn't flow unless you also want to say, well, the First Amendment doesn't apply to any kind of speech that was unknown at the founding, which, not so much. Because at least to my mind, the whole point of freedom of press, again, the way I interpret press, is technology. So I interpret freedom of press as referring to technology. So it's technologically agnostic is the way I interpret freedom of press. It has nothing to do with newspapers or reporters or anything like that, at least to me. It has to do with technology, so it's technologically neutral. So that's the way I tend to think about that. So that's good stuff. Yeah. Phoenix asks, an originalist philosophical question here. Sure. Does that mean to ensure that you don't need to use an analogy, amendments would have to be re-ratified to have modern context in mind? No, again, to an originalist, you are looking to what it was meant to encompass, and you're looking to the case law and what it was meant to encourage and not. And so I don't think so. I think an originalist says, well, what was the scope of the meaning at the time, and how would that apply to the current situation? So I don't think I don't think you need to be that originalist about it. I don't know if there's anyone that originalist. That would be a really interesting originalist position. That'd be a really interesting originalist position. It's like, so that'd be a interesting confluence. So the Second Amendment, when it says shall not be infringed, means no infringement at all. But the only arms that are protected are those that were known at 1791 and nothing more. That would be an interesting originalist interpretation. That would be a little bit Justice Black-esque. Justice Black was a little bit that way on the First Amendment. So he thought the First Amendment was absolute, but he thought freedom of speech meant literally speech and nothing more. So Justice Black would have said, no restrictions on freedom of speech are valid, none of them, but freedom of speech. So not expression. So like literally the words and nothing more. So Justice Black would have no problem with banning any kind of expression that isn't speech. So, any kind of regulations that doesn't literally involve literal words would have been okay by Justice Black. But any regulations not involving literal words is not okay. So Justice Black was a little bit that way, but we haven't had anyone like that since Justice Black. And I think Justice Black was a little bit, off the rails on that one, but that was his idea. So I think it's probably for the best we didn't adopt that. So the Second Amendment would mean literally absolutely no infringement of any kind, but would only apply literally to the firearms that existed in 1791, nothing more. That'd be a Justice Black kind of interpretation. But, fortunately no one is like that today. Yeah, the idea of flipping off a cop is a pretty modern concept. That's true, but at least to the originalist, we're trying to understand like what it does or does not mean, and it's within the scope of freedom of speech. So, new questions being raised all the time, but we're trying to figure out like what it was trying to talk about. What were the ideas embedded in the words? And how do we apply that to the current situation? So, pretty good stuff. Yeah. Pretty good stuff. Yeah, it's pretty good stuff. So yeah, I think for me for an originalist, you're trying to look to what it meant at the time, almost in a philosophical way. What is the philosophy embedded in the concept? What was the philosophical understanding of it embodied in the words? Is probably the one way to look at it that's probably pretty helpful. Because what is the freedom of speech? What is the philosophical concept that's embedded in that? And it's also one of the reasons that you can look to like something that was passed relatively in common with the First Amendment, like the what's it called, the freedom of speech restriction that was passed very shortly after there. I can't remember the name of it, but it was later found to be unconstitutional because the philosophical idea embedded in the First Amendment was not in keeping with it. Can't remember the name of it right now. It is a little illegal archaeology, yes. Okay, well, I'm going to stop the stream and get back to work, but I appreciate you joining me. I hope this was helpful. If you like this, please give me a like. Yeah, the Sedition Alien, the Alien Sedition Act. That was the name I was looking for. Thank you. Yeah, Alien Sedition Act. That was what I was looking for. Thank you. If you like the stream, please give it a like as always. Thank you for the super chat. I will do Whitney versus California on a future recording and respond to it. So thank you for that contribution. And till later, my friends, hope you're well. Till later, cheers and goodbye.